complaint. The formal legal document filed by the plaintiff that officially begins a civil lawsuit identifying the parties involved, describing the alleged wrongdoing, and stating what relief or remedy is being sought from the court. Indictment. A formal written accusation issued by a grand jury charging a person with a serious criminal offense, based on a finding that there is probable cause to believe the accused committed the crime. Information. A formal criminal charge filed directly by a prosecutor without the involvement of a grand jury, typically used for misdemeanors or in jurisdictions that allow prosecutors to bypass the grand jury process. Grand jury. A group of citizens convened in secret to review evidence presented by the prosecution and determine whether there is sufficient probable cause to formally charge a person with a crime and proceed to trial. Probable cause. The legal standard requiring that law enforcement or prosecutors have a reasonable basis, supported by facts and circumstances, to believe that a crime has been committed or that a particular person committed it. Statute of limitations. The legally defined deadline by which a lawsuit must be filed or criminal charges must be brought, varying by jurisdiction and type of case. Once expired, the claim is generally barred forever. Standing. The legal requirement that a party bringing a lawsuit has a sufficient connection to and harm from the law or action being challenged, establishing their right to have the court hear their case at all. Arrest. The act of a law enforcement officer taking a person into legal custody based on probable cause that the person has committed a crime, triggering the formal beginning of criminal proceedings against them. Miranda writes, "The constitutional warnings that law enforcement must deliver to a suspect before a custodial interrogation, informing them of their right to remain silent and their right to an attorney, stemming from the Fifth and Sixth Amendments." Booking. The administrative process following an arrest in which law enforcement records the suspect's personal information, photographs them, takes fingerprints, and logs the alleged offense into the official record. Initial appearance. The first time a defendant appears before a judge after arrest, typically within 24 to 48 hours, where the charges are read, rights are explained, and the question of bail or pretrial release is addressed. Arraignment. The formal court proceeding in which a defendant is officially informed of the criminal charges against them and is asked to enter a plea of guilty, not guilty, or no contest. Bail. Money or other security deposited with the court to secure a defendant's release from custody before trial, serving as a financial guarantee that the defendant will appear for all future court proceedings. Bail hearing. A court proceeding in which a judge determines whether a defendant should be released before trial, and if so, under what conditions and at what financial amount. Own recognizance, OR. A form of pre-trial release in which a defendant is freed without posting bail, based solely on their written promise to appear at all future court dates, typically granted to low-risk defendants. Remand. A judge's order sending a defendant back into custody, either after denying bail, revoking pre-trial release, or returning a case to a lower court after an appellate decision. Pleading. Any of the formal written documents filed by the parties at the outset of a case that define the claims, defenses, and issues in dispute, establishing the framework for the entire litigation. Answer. The defendant's formal written response to the plaintiff's complaint, admitting or denying each allegation and raising any affirmative defenses the defendant intends to rely upon. Affirmative defense. A defense raised by the defendant that, even if the plaintiff's allegations are true, provides a legal justification or excuse that defeats or limits the claim, such as self-defense, statute of limitations, or consent. Counterclaim. A claim filed by the defendant against the plaintiff within the same lawsuit, asserting that the plaintiff has actually harmed the defendant in some way related to the original dispute. Cross-claim. A claim filed by one co-party against another co-party on the same side of the lawsuit. For example, one defendant suing another defendant, typically alleging shared or shifted responsibility. Demur. A formal legal objection arguing that even if everything in the opposing party's pleading is true, it is still legally insufficient to support a valid claim, effectively asking the court to dismiss the case without a trial. Amendment. A revision or correction made to a previously filed pleading, allowed by the court under certain conditions, to add new facts, correct errors, or adjust the claims or defenses being asserted. Summons. An official court document served on a defendant notifying them that a lawsuit has been filed against them and directing them to appear in court or file a response within a specified period of time. Service of process. The formal procedure of delivering legal documents, such as a summons, complaint, or subpoena, to a party in a manner that satisfies legal requirements and officially puts them on notice of the proceedings. Subpoena. A court-issued legal order compelling a person to appear and testify at a legal proceeding or to produce specific documents, records, or other evidence. Subpoena duces tecum. A specific type of subpoena that requires the recipient to bring designated documents, records, or tangible items to court or to a deposition, rather than simply appearing to testify. Quash. To formally challenge and seek cancellation of a subpoena or other legal process, typically by filing a motion arguing that the demand is improper, overly burdensome, or legally defective. Discovery. The pretrial phase in which both parties are legally entitled to obtain relevant information, documents, and evidence from each other and from third parties, designed to prevent surprise at trial and promote fair resolution. Deposition. A formal out-of-court proceeding in which a witness or party answers questions under oath before a court reporter, creating a sworn transcript that can be used at trial or for further investigation. Interrogatories. Written questions submitted by one party to another that must be answered in writing and under oath within a specified time period, used to gather basic factual information about the opposing party's case. Request for production. A discovery tool by which one party demands that the opposing party provide copies of specific documents, electronically stored information, or other tangible items relevant to the case. Request for admission. A discovery device asking the opposing party to formally admit or deny specific factual statements, used to narrow the issues in dispute and establish undisputed facts before trial. Deponent. The person who is being questioned and giving testimony during a deposition, whether a party to the case or a third-party witness. Privilege. A legal protection that shields certain communications or information from being disclosed during discovery. The most common being attorney-client privilege and the work product doctrine. Work product doctrine. A legal protection shielding an attorney's notes, strategies, mental impressions, and case preparation materials from being disclosed to opposing counsel during discovery. Protective order. A court order limiting or restricting the disclosure of certain sensitive or confidential information obtained during discovery, often used to protect trade secrets, personal data, or proprietary business information. Expert disclosure. The pre-trial requirement that each party identify their expert witnesses and provide a summary of the opinions those experts intend to offer at trial, giving the opposing side an opportunity to prepare a response. Venue. The geographic location, the specific court or county where a case is to be tried, determined by rules about where the events occurred, where the parties reside, or where a contract was to be performed. Change of venue. A court order transferring a case from one geographic location to another, typically requested when pre-trial publicity or local bias makes it impossible to seat an impartial jury in the original location. Jurisdiction. The legal authority of a court to hear and decide a particular case, which must be established both over the subject matter of the dispute and over the parties involved. Subject matter jurisdiction. The court's authority to hear cases of a particular type or category. For example, federal courts have subject matter jurisdiction over federal law claims, while family courts handle domestic matters. Personal jurisdiction. The court's authority over the specific parties in a case, generally established by the defendant's presence, residence, or sufficient contacts within the court's geographic territory. Forum non conveniens. A legal doctrine allowing a court to dismiss or transfer a case to a more appropriate venue when another court or jurisdiction would be significantly more convenient for the parties and witnesses. Motion to dismiss. A pre-trial request asking the court to throw out the case entirely on legal grounds, such as lack of jurisdiction, failure to state a valid claim, or expiration of the statute of limitations, without proceeding to trial. Pre-trial conference. A meeting between the judge and the attorneys for all parties held before trial to discuss scheduling, narrow the issues in dispute, explore settlement possibilities, and plan the logistics of the upcoming trial. Scheduling order. A court-issued document establishing the timeline for all pretrial activities, including deadlines for completing discovery, filing motions, disclosing experts, and readying the case for trial. Stipulation. A formal agreement between opposing parties on a particular fact or procedural matter, submitted to the court, that eliminates the need to present evidence or argument on that specific point. Settlement. A voluntary resolution of a dispute reached by the parties themselves without a court verdict, typically involving one party paying money or taking some agreed-upon action in exchange for the other dropping the lawsuit. Mediation. A voluntary, confidential process in which a neutral third party, the mediator, facilitates discussion between the disputing parties to help them reach a mutually acceptable settlement without going to trial.